Welcome, everyone, to another episode of Conversations in Civil Justice. My name is Richard Jolly. I'm a professor at Southwestern Law School in Los Angeles, California, and I also serve as a fellow for the Civil Justice Research Initiative of UC Berkeley School of Law. While everyone is getting settled, I want to let you all know about some programs currently being offered here at UC Berkeley. Specifically, the following opportunities are being offered to help advance your career. The first is Leadership in the Legal Profession, which returns in April of 2022, and Navigating the Board's Role also returns in April. You can learn more about these and other courses offered by Berkeley Law Executive Education on their website, executive.law.berkeley.edu. But right now, I am thrilled to welcome you to this 16th episode in a series of webinars sponsored by the Civil Justice Research Initiative. The CJRI is an academic initiative that explores, through interdisciplinary, university-based research, how the civil justice system can be made more open and available to all of those seeking relief. Central to these programs is and continues to be audience participation. We aim to foster a conversation. So please feel free to submit questions using the Q&A feature at the bottom of the Zoom, and we will address them throughout our conversation. Today's episode will focus on sex abuse litigation. But before I introduce our guests, I am so excited to be introducing my co-host, Jenna Forster. Jenna is a third-year student at Berkeley Law. During law school, she has served as an executive editor of the Berkeley Journal of Gender, Law, and Justice and the California Law Review, and has served as the co-director of the Berkeley Law Trial Team. She's also the founding member of the Berkeley's Plaintiffs' Law Association, and after law school, she will begin her career at a plaintiff side litigation before going on to clerk on the Northern District of California. We are so pleased to have her help moderating this fantastic discussion. Jenna, thank you so much for being here.
Thank you, glad to be here.
And we also have, of course, our guests. Our guest, John C. Manley, and we could not have secured a better speaker for today's program. John is the nation's preeminent attorney representing victims of sexual abuse and assault. Over the past 25 years, John and his team have been heavily involved in the most significant sexual abuse actions litigated across the country. This includes serving as lead counsel for the victims of former Olympic women's gymnastics team, Dr. Larry Nassar, and as lead counsel for the 710 victims of the former USC gynecologist, Jordan Tyndall. And in February of just this year, he helped secure a $246 million settlement against the UCLA gynecologist sex abuse litigation. John, I can't tell you how happy we are to have you here with us today.
Well, thanks for having me.
Well, Jenna, maybe you could get us kicked off with the first question here.
Absolutely. John, we're so glad to have you here and to be having this conversation. And I want to start by doing a little bit of table setting. So for folks who may not be tuned into all the details, can you give us maybe a sense of the landscape, the current state of a lot of this litigation in this area?
Sure. So sex abuse litigation really started in this country in the 80s, primarily against the Catholic Church. The first case was against a priest named Father Gilbert Gauthier in about 1987 out of the diocese, a diocese in Louisiana. And Father Gauthier was a virulent predator, hundreds of victims, and that case settled for a nominal amount relative to today's values. It sort of continued, and basically the sort of the modern, I would say, genesis of sex abuse litigation was the Boston diocese cases in 2001, 2002. Sadly, those cases, because believe it or not, Massachusetts has charitable immunity, settled for $30,000 apiece, including horrific rape. So anybody that ever saw the movie Spotlight, you would think that those victims were going to get a significant amount of money to compensate them for a lifetime of suffering, and they didn't. In 2001, we settled a case involving a young man named Ryan D. Maria. Ryan's name is public, otherwise I wouldn't wouldn't use the name. And we filed that case in 1997. It was the first sex abuse case I ever filed. And to sort of give you a flavor for it, when we filed it, I tried to settle it beforehand, basically for nothing, because at the time I was still Catholic. And the diocese lawyer told me to go fuck myself, literally. So we settled that case for $5.2 million in July of 2001, which until last year was the single largest settlement for a priest victim before trial. What happened then is that basically throughout the 2000s, there were a lot of Catholic cases, some Boy Scout cases, a few others, but really in California, not a lot of public school cases. And in 2012, we were able to get the California Supreme Court to change the law and allow public schools to be sued, sort of abolishing the doctrine of sovereign immunity, which was a real problem in suing public schools in California. Since then, I always joke every car crash lawyer in the state has become a sex abuse lawyer, which is unfortunate because sex abuse is actually a very complex area of the law. The statute in California is called Code of Civil Procedure 340.1. It's a very technical statute. But
when was that passed, John? You were saying before the sovereign. Yeah, do you know, did that come after the sovereign immunity questions or? Okay.
No, 340.1 pre-existed it. It's been around since the 80s and has had probably 4 amendments. The last one was 2 years ago. So for example.
You said it's technical. What makes it so technical?
Well, for example, what's the standard of proof? Is the standard of proof negligence? Is it notice, meaning did you know or should have known? And the defendants will tell you it's actual notice, it's not, but you really need to know the case law in this area to litigate the cases effectively, because the defendants frankly just lie. And on the public school side, they're really very organized. They don't have an insurance company per se. They have joint powers authorities that buy insurance for them and that handle the claims. And they're public entities that are supposedly regulated by the Secretary of State, which nobody regulates them. But in any event, the Nassar in 2016, I got a call about a young woman named Jamie Dancher. Jamie, in my opinion, is the sort of the unsung hero of the Nassar cases, and frankly, of modern or current sex abuse litigation. Jamie was a bronze medalist from 2000. She then went to UCLA, has more perfect 10s than anybody in the history of U.S. women's gymnastics. She's a 6-time national champion. And you say, how can she be a national champion 6 times in 4 years? She has 4 individual championships and 2 team championships. So a remarkable young woman who was horribly abused by Larry Nassar. And I didn't know anything about gymnastics. I was a gymnast when I was young. That's a total lie. I was not.
Excuse me.
Yeah, that's all right. And she told me about this physician. So, and what he was doing was conducting ungloved pelvic exams on her and all of her teammates, basically. So, I did my due diligence on that procedure. And then right about this time, the Indianapolis Star published a series, and this was in July or August of 2016, right before the Olympics, published a series of articles on sexual abuse in gymnastics having nothing to do with Larry Nassar. And I simply called the reporter, whose name was Marissa Karakowski, who's now actually the lead investigative reporter for USA Today, and said, have you ever heard of Larry Nassar? And she said, yes, I've gotten 3 calls. So we filed Jamie's case initially as a doe. USA Gymnastics, in my opinion, almost immediately outed her name on social media. So everybody knew who she was. So she eventually decided to go public. They called her ex-boyfriends. They tried to dig up dirt. They called her an alcoholic. They called her, all kinds of a whore, all kinds of names. There were everybody.
John, let me ask: is that the kind of treatment that a lot of survivors who come forward deal with? Is that typical in this litigation?
It is sometimes, but I've never seen anything like the pushback that she got. Everybody now thinks, oh, Larry Nassar, bad guy, but Nassar was an amazingly popular figure in gymnastics. He was beloved, and that's very typical of predators. Frankly, we all think of predators as some guy with no pants and a trench coat walking around in an elementary school you could spot immediately. And the truth is, it's never that guy. It's the nicest, kindest, most decent, willing to help person is typically who you see, person you think you can trust, because they're very good at it. In any event, when Nassar really flipped when he was found with having child pornography, and he was federally charged, but no thanks to the FBI, because we now know the FBI was in collusion with USA Gymnastics and the U.S. Olympic Committee to hide Nassar. And you don't have to believe me. There's an Office of Inspector General report that says it, that they were helping USA Gymnastics with their press releases. They were concealing Nassar from Allie Raisman, from Simone Biles, from Michaela Maroney, from Maggie Nichols, all of whom I represent, for over a year after they reported. And it wasn't until Ms. Dancher's lawsuit that happened. In any event, the case we filed against Michigan State, USA Gymnastics, the Michigan State case settled, I believe, in June of 2018 for $500 million. And that very day, the LA Times broke the story on George Tyndall, who Dr. Tyndall is still criminally charged. He's waiting trial, was the 35-year campus gynecologist for USC, hundreds and hundreds of victims. And I'm proud to say we settled that case for $1.2 million apiece for nearly $1 billion last year. Then UCLA, as you mentioned, we just settled, and then we finally were able to settle the USOC USA Gymnastics case. USA Gymnastics eventually filed bankruptcy in 2017, but I mean, it took us this long to get it done. We settled that case this year. So what we're seeing in sex abuse is a lot of these longtime perpetrators, a lot of physicians who all seem to be in academic settings, which is odd.
Yeah, John, I wanted to push about that. What is this academic setting? Is there something unique about the academic setting? Is that where there's just a lot of this particular type of these physicians are employed? You talked about a pattern here, and the pattern that I keep seeing as well, especially in your work, are the universities. What's going on here?
Well, I think it's because, we all think of universities as being well run and people in charge, and the truth is, in most universities, including the UC system, there's no one in charge. The regents are supposed to be in charge, but what you find is that these departments are often individual fiefdoms, and for whatever reason, the impulse of seemingly every Title IX officer or every general counsel that I've encountered at a university is to cover it up. So, for example, George Tyndall, and that brings us to the use of non-disclosure agreements, or NDAs. George Tyndall was fired in 2016 for molesting a student, and he was paid $200,000, and they got him to sign an NDA. And of course, USC didn't disclose it. So lack of disclosure, and it's not just those schools, it's Columbia University. It's, the Duke University has a hospital in Pennsylvania where there's a perpetrator pediatrician named John Bardo. And I think it's because academia just does not have the rigor that you would expect in terms of controlling its employees. I mean, it's bizarre how uncontrolled it really is. And for example, in UCLA, Dr. Heaps, half the university knew that he was doing this, and for years. I mean, it's important to remember that we didn't get these settlements because we proved that he abused. We can prove he abused all day long and still not have liability. For liability attached, in most of these cases, we have to prove that the university or the employer knew or had reason to know this person was a perpetrator. In other words, molesting patients. And we were able to do that. So that's a very in my view, that's a very troubling sign that, USC is the largest employer in the city of Los Angeles. UCLA is probably the second largest employer, and both of them had predator physicians still operating. And I think people would be shocked to know that there's hundreds of doctors right now in California who've been criminally convicted or administratively convicted of molesting their patients who have their license and are practicing medicine today.
So what needs to, this problem that seems, if not particular to public institutions, really seems to be a big factor for public institutions. What needs to change? Who are the actors here who need to do something to stop this?
Well, it falls under two categories. Number one, child sexual abuse is almost always done by people in positions of trust: teachers, religious, priests, physicians, etc. All of whom, by the way, are mandatory reporters, and they often happen in a school setting. When's the last time you read about a teacher being charged for failing to report? It almost never happens. Finally, we have a DA in San Bernardino who just charged 2 teachers in Rialto. But I've been doing this for 30 plus years. That's the first time I've seen anybody charged. In Nassar, there was the head of the medical school went to prison. A coach was convicted, and now her conviction was now reversed, and now it's on appeal. And the president of the university was charged but never convicted, and didn't go to trial. That was dismissed, and that's on appeal as well. Nobody at the U.S. Olympic Committee or USA Gymnastics has been charged, save Steve Penny, who was the president of USA Gymnastics, and he's been charged with destroying documents by a little DA in Texas where the Caroli Ranch was. But we have FBI agents lying. If you or I lie to the FBI, we go to prison for 5 years. It was a and we're about to bring a case against the Justice Department and the FBI on behalf of our clients. But I think the answer is you have to hold people accountable criminally who enable perpetrators. The only thing
questions from our audience. Sorry, I just want to make sure, because we're kind of talking around a question that just came from our audience about cases that are settling.
Yeah.
And the specific question is, what % of them settle? Something you said earlier suggested that it's not an evidentiary issue. At least that's what I seem to hear from you, that it's usually not an evidentiary issue. It might be an issue with the law or with might be some type of collusion you're describing. Is that generally what percentage, and what is forcing settlement rather than trial or these criminal charges going bust?
So obviously the criminal cases almost always go to trial. They probably 70% of the time those cases get tried. And frankly, in a case where we've been involved, we've never had a perpetrator acquitted. Now, obviously, we don't prosecute the criminal cases, the DAs do. But in civil cases, probably 95% of them settle. I haven't been to trial on one of these since 2016. We tried a case there against LAUSD for 2 children who had a convicted perpetrator. It was a school called Telfair Elementary. This particular perpetrator, whose name was Paul, I can't remember his last name, apologies, was charged criminally with molesting his neighbor while he was a teacher, went to trial. There was a hung jury, and LAUSD did no investigation, put him right back into a classroom in Pacoima, which is a very low-income Latino area in northern LA County, told no one, and he went right on molesting children. And so we brought that case. I think the pretrial offer was $150,000. And we tried it. My partner, Vince Vonaldi, and I tried it. And the verdict was $6.2 million for 2 boys. no punitive damages because it's a public entity. Vince has tried 2 or 3 cases since then, but and frankly, I'd like to try every single one of them, because every time we do that, it sends a message. Obviously we have a duty to our clients, and the defendants offer a certain amount of money. You can't advise your client not to take it. So, but the thing about the money is that, I talk about money, and the truth is we don't chase money. I tell my clients in the first meeting, what you want to chase here is healing. Money is simply the symbol of the harm done, and frankly, the pain we can inflict on the defendants, so to ensure they don't do it again. And that's why we do what we do. And I'm really proud of the work we've done, because I think it's made a difference. I also say that, people say, "Oh, great lawyer, great lawyer." I'm not a great lawyer. I'm an average lawyer. What I have are amazing clients. And the value in these cases, and the reason we have success, is our ability to let our clients tell their story. And what I can tell you is, if you have a conservative jury, a liberal jury, a moderate jury, if we can get the client on the stand and tell their story, the defendants are dead.
John, I'm glad you brought up, that you say that you and your clients are not chasing money, that what you're looking for is healing. And one of the things that I found interesting was that, for instance, the USA Gymnastics settlement, there were some other terms to that settlement, aside from obviously a large dollar amount. Can you talk about some of those terms and why they were important to your clients and how that happened?
Well, yeah, it was very important to the bankruptcy committee, which consisted all of the survivors, that they try to bring change to USA Gymnastics. So there were a bunch of non-monetary concessions, including putting people on the board. And we've done that in many, many cases. I have to tell you, though, I'm kind of dubious about them. I think they're important, but frequently the defendants simply ignore them and use them as public relations cover. So, for example, USA Gymnastics, actually, there's a story this week that they're competing in Germany, our national team, and the coach they appointed is Valery Lukin, who actually has current child abuse allegations pending in Safe Sport. And the allegations are that he starved his athletes, was severely emotionally abusive, calling them fat pigs, and denying them water, and really significant stuff. Not sexual abuse, but what amounts to physical and severe emotional abuse. Okay. So call me crazy, but you just got out of a bankruptcy. You've got hundreds of victims in your wake, and this is who you choose to coach. And what that tells me is, and what I suspected is, it's not salvageable. USA Gymnastics needs to be decertified. In other cases, like in the Catholic cases, for example, I think it's had a better effect. Not that the Catholic bishops have really changed, but they're so petrified of moral liability that they've adopted policies that we sort of designed. I was a naval officer, and the first time I did that, I designed those, I based those on the tailhook scandal, which was a scandal 20 years ago, where the Navy adopted some pretty significant reforms in terms of disclosure, in terms of an 800 number that you can call, and things like that. And that's helpful, but it depends on the institution. I think, frankly, academia probably does a better job in adopting those reforms than religious institutions. They're important, but I really believe that what they need mostly is a forgive me, but a bat to the head, so they never do it again. Because you're talking about people's lives here,
John, in terms of some of these reforms, one of the questions from our audience concerns non-disclosure agreements. Mm-hmm. And I wonder if that is posing a hurdle in this area. It sounds like it is. And particularly as you start proposing these reforms, has any of the terms included saying, look, you got to get rid of the NDAs because that is such a hurdle here. When we're putting in terms these settlements, no more NDAs.
I couldn't agree with you more. Frankly, Harvey Weinstein exists because a certain, and was allowed to get away with it because a certain plaintiff lawyer in LA and New York, who I won't name, signed NDAs for years, and she still does it. And we don't do it. Gagging, and let me give you a really prime example. One of our clients is Michaela Maroney, and Michaela, you might remember, was famous for the that look in 2012. She was one of the greatest Olympic gymnasts in history, and Larry Nassar was literally raping her at the Worlds. He molested her and Allie Raisman and that entire team at the games. She came forward and hired a certain lawyer in 2016 after Jamie Dancher's case was filed, and was forced by USA Gymnastics to enter into a non-disclosure agreement, where if she talked about Nassar, she was going to have to pay $200,000, and her parents were going to have to pay it, even though her parents weren't parties to the agreement. And the lawyer at the time, agreed to it. I'm very proud that when we filed her case, because she didn't settle with Michigan State or the U.S. Olympic Committee, we filed a declaratory relief action to declare that NDA void. Under California law, lawyers in child sex abuse cases cannot enter into an NDA with a penalty of discipline if you do, bar discipline, that is. There are cases where there is a rare case here and there with an adult where an NDA is proper to protect the victim's privacy, but those are few and far between. And in my view, signing an NDA in a child sex abuse case, all that does is enable the perpetrator. And I applaud the legislature and the governor for signing that bill, and hiding somebody else's crime so they can go on and do it to somebody else makes you responsible. And I will not have my clients, carry that burden. So.
John, you've talked a lot about your relationship with your clients, and it's clear how much respect you have for your clients and for their courage in coming forward. And I think that touches on one of the questions from our audience members, which is, what kind of training do people doing the work you're doing need to do to work with clients who've obviously been through these really traumatic experiences?
Right. So, one of the worst things you can do with a client is sit down and just say, "Oh, tell me what happened." You have to recognize that you have to have a trauma-informed background and have training. And frankly, our intake people are all retired law enforcement who were sex crimes detectives. So they have extensive training and extensive experience in interviewing sex assault and sex abuse victims. The first thing you want to say, in my opinion, to a sex abuse victim is, "I'm so sorry this happened to you, and it's not your fault." Even though they know it, verbalizing that is so important, because most people don't recognize that especially child sex abuse victims, there's a part of you that feels like it's your fault, because the perpetrator sort of inculcates that in you. So verbalizing, "This is not your fault, and I'm so sorry it happened to you," and very frequently, me or my staff are the first people they've shared their story with. The other thing to remember is you're not going to get the full story in the first interview. It takes time to disclose it. It doesn't matter if you're 10 or 90. Disclosure on this is slow. It's slow because frequently, even though you're an adult, you're talking about something that happened to you as a child. And if you're an adult, you're talking about something that was very, very traumatic. And you may not be able to articulate everything at the first time. So I think understanding that you're dealing with people who are really hurt And, my view is don't, do no harm. If I sense somebody is too fragile to do this, I tell them not to do it. The other thing I'm really shocked at is how many lawyers take their clients and put them in front of a camera immediately, almost like a hostage video. And I think we all know what I'm talking about. And it's wrong. Some clients absolutely want to go to the press. They do. But my advice to them is you can't take it back. Don't do it unless you want to do it. Jamie Dancher had to do it because she was outed. Her name was out there, and she elected to do 60 Minutes, which was incredibly powerful. But that's the rare situation. I have had USC clients and UCLA clients that wanted to be public. One of whom was a woman named Audrey Nofziger, who was a sex crimes DA in Ventura County, very, very strong woman, and went public, and a few others. But for most people, that's not right. And if you put your clients out there for the sake of media, because you want to be famous or you want your name in the paper, you're doing tremendous harm. So I hope that answers your question.
John, you have done a fantastic job covering this topic for us. I'm so sad that we are out of time, that we need to wrap up. I can't thank you enough for providing this fantastic review of this very complex and very emotionally weighted area of the law. And Jenna, it's been just a pleasure to have you here to host this conversation with. I also want to thank the executive director of the CGRI, Ann Bloom, Berkeley Executive Education, and everybody else who helped make this conversation possible. I also want to quickly remind everybody that we have more conversations in civil justice coming up. On April 15th, we will be covering access to justice and arbitration with Carla Gilbride, who will be arguing Morgan v. Sundance next week in the Supreme Court, and Sarah Stazak, who is the author of the book No Day in Court. And on May 6th, we will have Dahlia Lithwick and Professor Michael McCain, to be discussing journalism and the law. Thank you again, John. Thank you again, Jenna. And thank you to our fantastic audience.
Thank you.
Thank you.